Well, wouldn't you know it, it's tax time again. This time spurred on by a question left on our video all about California's scheme to increase your property taxes. Great video, by the way, highly recommend. Here we've got a question on what are the various tax implications and inheritance concerns on your children inheriting a secondary or vacation property, and what would be the best way to do it. Great question. Let's talk about inheriting a secondary property and everything your children will have to deal with when inheriting that second property of yours. Don't forget to like and subscribe and share the video with that kid of yours who keeps bugging you to set up your own estate plan, and let's dive in. Let's begin with discussing the character of the property in question. Secondary or vacation property versus a primary residence, and property taxes, since it's likely our immediate concern. There are going to be different rules depending on whether the property in question is a primary or secondary property when it comes to property taxes and capital gains taxes if you were to sell the property during your lifetime. Your primary residence is pretty straightforward. It's where you live. The IRS calls this your domicile and characterizes it as the location you maintain a permanent residence at and to where you return whenever you leave, for example, on vacation. A secondary property is going to refer to any other properties you may own that are not your domicile, whether it be rental, vacation, speculative investment, vacant land, whatever. If you have a property that's not your domicile, then that's your secondary property. This leads us to property taxes. I have a whole video where I go into extreme depth about California property taxes and how they're calculated, how much they can change over time, and when you can expect large spikes. It's a great video, so I'll link to that in the corner as well as in the description. It's long, but I promise you that after watching the video, you'll know everything you need to know about California property taxes. It's also the video that sparked this question in the first place. However, we'll cover a few key points on property taxes today. Property taxes are, of course, a tax you pay to the county based on the county's assessment of how much your house is worth, the assessed value. In California, there are two propositions that provide some limits on how the county can determine the assessed value of your property. Propositions 13 and 19. The assessed value of your property can generally only be increased by a maximum of 2% per year, meaning the amount you pay in property taxes each year can only go up by about 2%. However, property values generally tend to grow by about an average of 4 to 6% per year in California. That means that the longer you own your property, the more out of step your property's assessed value will be when compared to its market value. This can lead to a case where a couple only pays a few $100s a year in property taxes, while their neighbors pay closer to $25,000 a year simply because that couple has lived there for decades. I've seen this exact scenario before. There are various cases where a county is allowed to reassess the property value, thereby increasing the property taxes to bring it more in line with the market value at the time. Generally, this is due to there being a transfer of the property, for example, a sale. However, even then, there are exceptions. The relevant exception today is the transfer from parent to child or vice versa. Under Prop 13, any transfers between parent and children could avoid a reassessment. However, under Prop 19, passed in 2020 and went into effect 2021, said transfers could only avoid a reassessment so long as the property was the principal residence of both the parent and the child. That means that when the secondary property is transferred to your children, the property taxes are going to be reassessed as of the date of transfer or death if it's the result of an inheritance, and the receiving children are going to have to do some math. Is it worth the increased property tax bill to keep the house, or is it too expensive and thus they have to sell the property? Of course, the next question is, what's the best method to transfer that property to the children in the first place? Well, it's a living trust, of course. You should be holding most of your assets, especially real estate, in your living trust so that those assets can be passed on to your children very easily and with minimal cost. I talk about living trusts and avoiding probate all the time, so I won't linger here. Just know that avoiding probate on your death should be a primary goal for estate planning unless you want your children to wait a year to get their inheritance and pay court and attorney fees of tens of thousands of dollars. Next, let's briefly discuss capital gains taxes. If you sell an asset for more than what it cost you to get it in the first place, then you made a profit on that sale, and that profit is subject to a tax, the capital gains tax. The capital gains tax applies to any asset you have: real estate, stocks, bonds, commodities, etc. However, there are two credits that can reduce your capital gains tax burden: a credit for selling your primary residence, and a step up in basis. Firstly, if you were to sell your primary residence during your lifetime, you will receive a capital gains tax credit of $250,000 per person, or $500,000 for a married couple. That means you need to make over that credit amount in gains before a capital gain tax would be imposed. But again, this is only for your primary residence, and there are some requirements that must be met in order to qualify. You must have owned the property for at least 2 of the past 5 years. You must have lived in the property for at least 2 of the past 5 years, and you must not have claimed this credit at least 2 years prior to the sale. Which means that if we're talking about a secondary or rental property, the no capital gains tax credit on the sale. Any and all profit is subject to a capital gains tax. But now you're probably thinking, that's great and all, but I don't plan on selling the property. My kids will get it. What happens then? Well, that's where that step up in basis I mentioned earlier comes into play. If someone inherits a property, by which I mean real estate, stock, securities, etc., then the recipient will receive a stepped up tax basis on that asset. That means their tax basis in the property, think acquisition value, will step up to the date of death value rather than whatever the initial purchaser paid to acquire the property in the first place. We don't care that mom bought that house for 10 grand and a pack of bubblegum. All we care about now is that the house was worth $800,000 when she passed away, because if we sell it for $800,000, then whatever is left after escrow, title, and the realtor take their cuts is just cash for that beneficiary to keep without Uncle Sam coming in with an outstretched arm. Again, this applies for other assets like securities as well. If your mom bought Apple stock for $10 a share, but you inherited at $220 a share, then sell, then you didn't make any money on the sale of those Apple stocks. No capital gains tax. Now, it would probably be a better idea just to keep that Apple stock, but that's a whole different discussion. As you can see, from a tax standpoint, it is better for your beneficiaries to inherit assets during your lifetime than it is for you to cash out those assets and only pass on liquid funds. Before we close out, I do want to quickly mention estate and inheritance taxes. The estate tax is a tax on one's estate when it reaches above a certain threshold, currently $13.6 million. If you pass on real estate, then the value of that real estate will count towards that estate tax threshold. Now, most people don't have $13.6 million in assets, much less $13.6 million per spouse for a married couple, so the estate tax only affects less than 1% of people. This figure is also indexed to inflation, but may be cut in half in 2026 if Congress doesn't reinstate the Sunsetting Tax Cuts and Jobs Act. Even then, the figure should be around $7 million and will still be indexed to inflation. We'll let you know how things shape out though. Also, keep in mind that states can collect their own estate tax, so check your state's laws for more. Most don't collect one, California being a state that surprisingly does not. Last, we have the inheritance tax. The inheritance tax is a tax paid by the recipient of an inheritance. It depends on where that beneficiary lives, so there's only so much we can do at the planning stage to work around that. Federally, there's no inheritance tax, but just like with the estate tax, states can levy their own inheritance tax. California is 2 for 2 though, no inheritance tax. Another tax I didn't mention is for LA City residents only, and that's what people call the mansion tax. Now, I've done a video all about the mansion tax in more detail, so I'll link to that so you can know more there. But for those in LA City, and depending upon the zip code, you would be included in there, certain properties, when sold, have an extra tax levied on top of them if they reach above a certain threshold. But watch that video to learn more. But what do you think? Do you have a question on what beneficiaries should expect when it comes to an inheritance? Anything I discuss surprise you? Let me know in the comments below. Be sure to subscribe so you don't miss out on any future uploads. I plan on discussing irrevocable life insurance trusts, the Democratic Party's tax proposals for a potential Kamala administration, and a little down the line, guns. Thank you for watching. Be sure to like, share, and leave a comment so YouTube shows us some love. I'm attorney Andrew Bethel, and I'll see you at our next meeting.